than the other extra one, I guess. Okay, thanks so much. You have a good night.
So when you get 2 extra shots of espresso and you frappuccino, it like turns into
All right. Welcome back. I started this one today, right? Okay. Please sign in when you can. If I seem a little distracted today, I am. The Supreme Court's term ends tomorrow. And this is, at least in my recollection, the most chaotic end of the term that I can imagine. Summary. None of this is for the exam, but you may find it worthwhile to study as well. Usually when the Supreme Court decides cases under tight deadlines, they do a crappy job. I think we're about to get one of those tomorrow. We've studied this before. For example, Youngstown, you'll recall, where the entire case was decided in about 20-something days. We also studied James and Morby Regan, where the case was decided very quickly. Think of Justice Tawney in Merriman. We decided the case basically overnight. That when judges have to hurry, usually have to forget about important concepts. As I'm sure you know, under the Constitution, every 10 years, a census to determine how many members of Congress each state gets. So if a state had an increase in population, they may get more members of Congress. If they have a decrease in population, they may get less members of Congress. The census is used to determine representation. Now, the number of people we count for representation is based on total persons, right? Not based on citizens. This was by virtue of the 14th Amendment. You count total population, not citizens. About 2 years ago, the Trump administration announced that it wanted to make a change to how the census is operated. Specifically, they wanted to add a question to the census: are you a U.S. citizen? Now, that information is not needed to count the representation for members of Congress. But the Trump administration said they needed that to perform some functions to the Voting Rights Act, which are not particularly important for here. That action was challenged in court by a number of states and civil rights groups, and they argue that putting the citizenship question on the census will decrease returns. Why? People who are not citizens may not fill it out because they're afraid to indicate they're not citizens with their name, their address, and their family members, and they may be afraid that immigration enforcement might result from that. So it would result in undercount in particularly non-citizen communities, and in our country, the bulk of non-citizens are Hispanic. Some states like Texas, which have high Hispanic populations, high Hispanic non-citizen populations would actually see a reduction in members of Congress. In other states, which have fewer immigrants, they would see an increase in their representation in Congress. Okay. The actual facts aren't relevant to your studies except for one critical factor. We are now in the last week of the Supreme Court's term. And we're running to this bizarre conclusion, which I don't know how it ends. Throughout the entire litigation, the government's asserted they're adding this question to help with the Voting Rights Act. And the plaintiffs said, no, you're doing this because you want to diminish the voting capacity of Hispanics. Or I think of footnote 4 on discrete and incidental minorities, which we'll be studying later today. Then the things of movies, right? A couple years ago, this guy died. Who was he? He was an expert on how to draw maps to maximize the political power of certain groups. He died. Okay. His daughter found his hard drive. And on his hard drive, he had all these documents, which suggests that the reason the Trump administration gave was not accurate. Again, he died years ago, right? But the evidence suggests that they were actually using some of this guy's research, which suggests that adding a citizenship question would diminish the voting of Hispanics. So after this case was argued at the court, the plaintiffs go back to the trial court. They say, we need to reopen this case for discovery to figure out what the role is between the Trump administration and this guy. And the lower courts have all basically held that discovery can go forward. The crazy part is the Supreme Court's deciding the case tomorrow, before these things have been resolved. So I've been scrambling to try to figure out what the heck the court's going to do, and we'll see tomorrow morning. But my prediction, I put this on Twitter for whatever it's worth, is the court resolves part of the case now and schedules a second round of argument for September, which is unusual, to resolve this other stuff from this guy's hard drive. It's all very uncertain what happens. And it's very chaotic because the court has basically announced that tomorrow's the last day of the term, which means all the opinions have to come out. So tomorrow morning, they got to do something. And if they try and decide this without the benefit of this hard drive stuff, it's going to look really bad because they haven't even considered the evidence. But usually the court doesn't wait around. They decide their things by the end of June. So as I said at the outset of class, whenever the court has to rush, they do a crappy job. And whatever opinion they put out might resolve the opinion of the day. Right? They'll resolve the case of the day. But then well, not you, you're done with ConLaw, but me, I'll have to then figure out what the hell it means and what it means going forward, which is going to make my life much more difficult. So my mind is somewhat elsewhere, but I'll be ready. Yeah, Lindsay.
So the Supreme Court goes into session and they decide what cases they're going to take that term, right?
That's right.
Okay, so they have to resolve what they decide.
They don't have to. Sometimes they can re-argue a case. What complicates this one, I forgot to mention an important fact, is that the government has said in order to print up the census forms in time, they need a ruling by June 30th. In other words, in order to have enough time to print the paper forms, they need a decision by June 30th.
So,
and the plaintiff said, no, the date's actually October 30th. So they don't even agree what the deadline is.
I think my question is more like, so they decide to take these cases. In the end, if they run out of time, are they allowed to be like, okay, we decided not to resolve this handful of cases, or do they have to rehear them the next time?
Well, generally, if they don't resolve a case by the end of the term, they re-argue it.
Okay, so they will.
Well, but the question is there enough time? In other words, if they don't decide it now, the government says they can't do the census. They need a decision by Friday or Saturday the 30th.
But if there's no deadline, if it's just like a regular.
Well, this happens in death penalty cases a lot, right? Think of it that way, right? If the state says we're going to execute a guy by tonight, and the court says, okay, we're not going to issue a decision before them, the guy's executed, and it's done. There have been cases where a person was executed and the decision was actually released after the fact. A very famous Supreme Court case called Ex parte Quirin, Q-U-I-R-I-N. It involved these Nazi saboteurs. It's stuff of a spy novel. Basically, these Nazis took a submarine and they washed up in, was it in Florida or Long Island? I'm drawing a blank. I think it was either one. They basically washed up on American shores. And Roosevelt basically said, I'm going to try these guys in a military commission. I'm going to execute them. And frantically, these Nazis appealed to the Supreme Court. And as they were appealing, Roosevelt was trying them basically in a court martial at the DOJ building. Right? It wasn't a real court. And the Supreme Court basically issued a one-sentence order saying, we're not getting involved. And then FDR executed them. And then at some point later, the court actually issued a written opinion explaining their reasoning. But the opinion didn't come out in time for the execution. And in fact, I think they were buried in unmarked graves somewhere in D.C. They didn't want to make like a martyr out of them. They basically just buried them in a field somewhere in D.C. It was a crazy story. Yeah, this was I can't remember if it was Florida or New York. They basically washed up on a shore somewhere, and they basically went to the FBI. They went to say, we want to talk to J. Edgar Hoover, right? We want to turn ourselves in, and like no one believed them. And then finally, they turned him in. One of the guys testified against the other, so he was spared execution. But a bunch of them they were executed by a court martial. And the court where they were tried was actually in the DOJ building, where the Office of Legal Counsel sits now. That's actually where the Nazis were tried. So your question, Lindsay, I think is well put. There's no artificial deadline except when someone's about to be executed, or in this case, the government says, where they need to print a format, they need time to print it. Now, I actually don't believe that. I think you could always find more time to print stuff, right? You pay some overtime to get it done. But if there's an actual deadline, right? Think of the Dames and Morvey Regan case. right? They had to resolve these disputes with Iran, right? They didn't have time to drag it out. They had to get it done. So Rehnquist wrote the opinion in 8 days, whatever it was. I think he wrote like 8 days or something. Of course, there's Bush v. Gore, right? Which I think you were all alive for, although that will soon change with my 1Ls in a few years. We had to have the election certified by a certain date, right? The Constitution says the elections be certified by a certain date. You can't go beyond that date. So they had to resolve it in, my goodness, like maybe 10 days, 7 days. I'm drawing a blank how many days it was. They had to resolve it. And the work product they produced was not their finest work. And there were like 5 separate dissents in Bush v. Gore, and I mean it was a mess. This was before high-speed internet and people were running around and trying to file things with paper. The court does not do well. So now all the parties are basically filing letter briefs to the court, like basically a one-page letter instead of a brief saying, decide this and don't decide this. You'll see me tomorrow. I'm going to be a mess. God, what are you studying tomorrow? Anything difficult? Oh, Brown. Oh, no big deal. Oh, we're doing Cooper v. Aaron. That's another one where the court decided on a short deadline. That was a case where school had to resume session by a certain date, and they had to issue the order to allow the kids to get to school by a certain date. So that was another case where they had an artificial deadline premised on when school would come back into session.
How do you think the court's going to rule on gerrymandering? Or have they decided that?
Oh, you're asking the other case.
Yeah. What do you think that they're going to do?
All right, so I'll answer your question. Take a step back. No, you're 4. You can ask whatever you want. You have no hesitation. All right, so what's a gerrymander? So actually the term should be gerrymander. Why? Elbridge Gerry was a Massachusetts politician, and he drew these maps in the shape of salamanders. That's what they called them. They called them gerrymanders, with these weird shaped maps that were drawn to give a certain group a greater voting power, right? Because if you have people who vote alike in a certain block, they'll vote for certain members, right? Okay. There are different types of gerrymanders. There's a racial gerrymander, where, for example, you could pack all minority voters in a single district, thereby diluting their power. So instead of having perhaps 2 members of Congress, they have 1 member. Or you can crack. There's packing and cracking, right? Where you can spread out minority members so they can never get above 50%. This entire idea is based on the premise that people who look alike vote alike. It's a bizarre stereotype, but it undergirds much of modern redistricting law, that if you put people who have the same race together, they'll vote the same way. I'll leave that for you. So you have racial gerrymanders, okay. But you also have something called the political gerrymander, where instead of trying to dilute the voting power of African Americans or Hispanics, for example, the legislature can draw these sophisticated maps to dilute the power of Democrats or Republicans. So in a blue state, they can make it impossible for Republicans to win office. And in a red state, they can make it impossible for Democrats to win office, right? There are districts like in Austin or San Antonio or Houston that are drawn in such a way that the Democrats have a tough time winning, and they exist in our own state. Because of computers, you can now draw with very sophisticated precision where to make these lines. So you can basically craft house by house where you should draw the line to minimize packing or cracking, as it's called. All right, so the first question is, can the courts even hear cases involving political gerrymanders? Are they, the word is justiciable, right? Is there basically jurisdiction to hear it? We studied in Marbury the first week of class that certain political questions should not be reviewed by courts, right? Marshall said we can review whether the commission should issue, because it's a ministerial task, right? It's automatic. It's commanded by law. But there's some discretionary matters that are called political questions. And the first question is a political gerrymander something that's political? Should courts just not decide this at all? Is there any standard by which you can even measure if something is unfair politically? Not racial, but politically. Last year, there was a case from Wisconsin that the court punted on. They had a sort of a weird technical ruling. This year, I suspect the court will hold that these gerrymanders are not justiciable, in which case courts can't review them. That might work to the advantage of Democrats or Republicans today, but At some point, Republicans will be in the minority, and they'll be upset by this. So the gerrymandering case is trickier. Now, where this gets even more fun, can a state draw maps based on not the total population, but based on voters or based on citizens? Which is why the Trump administration wants this information to allow states to basically draw maps based on citizen numbers, which would basically exclude significant representation from cities and shift more power to the urban, rural areas.
So they kind of affect each other.
Yes, they're very closely intertwined. Yeah, 1 second, I'll get to your hand. Right, so effectively, there was a case called Evanwell a couple of years ago, where basically a guy named Ed Bloom, who's the same guy that brought the UT affirmative action case, sued and said that the local jurisdiction in Texas was required to consider not total population, but voter population or citizen population. The court said, well, they're not required to, but they left open the question whether they're allowed to consider voter or citizen population, which would also exclude children who can't vote as well. In other words, why are you drawing maps based on people who can't vote? Are maps limited to those who can vote, or is map limited to total population? If the census data is obtained at that point, then you could draw maps based on citizen population. You don't adjust the number of representation you have, but you would effectively have less representation in the cities, which have high immigrant populations, and more in the rural areas, which have lower ones. Yes?
So would this,
I just dumped a lot on you.
would this be a section 4 kind of thing, or no, because it doesn't exactly have to
Voting
do with
age.
the voting?
Voting age.
Okay, so because it doesn't directly affect the voting.
So Section 4 of the 14th Amendment,
No,
someone.
not section 4, I meant footnote 4. Footnote 4.
Oh,
Whatever it-
I thought you were talking about the
like,
14th Amendment.
No. So footnote 4 says, about the elections and things like that are done with strict scrutiny.
Well, let me answer your question a little bit differently. I thought you were actually asking about the 14th Amendment, right? And if you remember in the 14th Amendment, I think it's actually Section 2, which I thought you were getting at, says that the Congress needs to determine whether states are depriving the right to vote to male citizens over the age of 21. And I actually blogged about this and said that means that you actually need to determine who are the citizens in the states to comply with Section 2 of the 14th Amendment. But you're asking the general question of footnote 4, which is fair game. Footnote 4 isn't law.
Okay.
It's not law. I mean, it's a theory, but the courts don't say this violates footnote 4. They'll sort of say that this changes the rules. They sort of allude to it, but that doctrine does not have much legs to stand on.
Okay.
I just dumped a lot.
I just wasn't sure if it
On
kind
you.
of fell in that category because it's the census, which is not directly, it affects voting, but I wasn't sure how closely they define.
Yeah, it's not about voting. It doesn't affect who can or can't vote. It affects representation,
Yeah, that's where
which might also fall in the footnote 4 umbrella. I think they'll make a very powerful argument, a dissenting opinion, but I don't think they'll carry the day. Anyway, so yeah, the gerrymandering case and the census case are going to be both decided tomorrow, and I suspect they'll both be by John Roberts, but maybe the census case by Alito. I'm not sure. I think things are still in flux. So Roberts always disappoints me. Hasn't really disappointed me yet. So it might happen tomorrow. I've been so far been not disappointed, really. No, not really. Let's go back to a simpler time. 1936. All right. Whatever drama we have today is nothing compared to what was going on back then. That was much more drama. But sorry. The only more questions? I didn't want to cut you off. That was a good transition. Okay, reset. Okay. Let's go back to the 1930s. Right? Where did we leave off yesterday? We left off yesterday talking about the personal liberty cases decided during the Progressive era. We did Meyer v. Nebraska. We did Pierce versus Society of Sisters. And we did Buck against Bell. And those cases were all premised on the notion that the word liberty in the Due Process Clause has substance, has content, right? That there's meaning to it. And that courts could determine what that meaning is. So some courts said that the word liberty means a liberty of contract. Other courts said that the word liberty can refer to the right to raise your children or the right to direct the upbringing of your kids. Although in Buck, the court didn't quite go down the road of saying that it includes the right to not have your genitals cut. But these decisions were unpopular in a lot of circles. And they were especially unpopular in progressive circles. The court was viewed as this conservative institution that was getting in the way of the democratic process, that the people wanted to enact certain progressive laws, and the state was getting in the way, both in terms of economic and personal. And then we flash forward to 1932. All right, President Roosevelt was elected in 1932. And we've already studied some of the Roosevelt cases. Right, we studied NLRB versus Jones and Laughlin Steel. Right, we studied Wickard versus Filburn. Right, we studied all these Commerce Clause cases decided during this era. And effectively what the court did was they overruled many of the progressive era precedents, like Hammer versus Dagenhart and E.C. Knight. And the court began to hold that Congress has expansive powers to regulate local activity. At the same time that this change was occurring, we also had a shift in how the court approached the Due Process Clause of the 14th Amendment. Again, same time, but we studied in the first half of the semester the federalism cases, right? And this often gives students a little bit of a brain freeze, right? But it was in the same period that the court expanded the scope of federal power and also expanded the scope of the state police power. These were simultaneous events that happened at the same time. Now, why did this change occur? This is a fascinating story. Most law students traditionally learn a story that goes like this. I learned it. It goes like this. Supreme Court in the 1930s, you have Schechter-Poultry, you have these sorts of decisions where the court says, Roosevelt, no, you can't do this, right? Then in 1937, Roosevelt proposes the so-called court packing scheme, which will allow the president to add one new judge for every judge over the age of 70. And not just Supreme Court, the entire judiciary, right? State and federal, Supreme Court, Circuit Court, and lower court, right? This will allow Roosevelt to appoint, I think, 4 or 5 new justices to the Supreme Court and hundreds of lower court judges, lots of them. The Supreme Court was worried that if the plan went forward, it would weaken the legitimacy of the court. So rather than pick a fight with Roosevelt, the court switched its position, the so-called switch in time that saved 9. And Justice Owen Roberts decided to change his vote, and he voted to uphold a Washington state minimum wage law. Okay, that's the conventional narrative, which is not true. I was taught it's not accurate. And the reason why we know it's not accurate is because we actually have the records, right? The justices would vote at the time at a conference, and many of the judges would write down who voted which way. And we know that Owen Roberts, not John Roberts, but Owen Roberts, cast his vote before the court packing plan was even announced, right? So Owen Roberts announced his vote long before Roosevelt announced his policy. So it's not the case that Roosevelt's court packing plan intimidated the justices or scared them or anything like that. Rather, we had new judges appointed. And we tell this story, I think, very effectively in Chapter 34 of the supplement. I'll walk you through it briefly. But the major reason why the court changed direction in 37 began long before Roosevelt was even elected. In 1930, we had President Hoover, right? Hoover was a Republican, but he was quite progressive. And he had 2 vacancies to fill in the Supreme Court. So first, Chief Justice Taft resigned, and Hoover appointed Charles Evans Hughes, who was a former governor of New York. He ran for president, really influential guy, as Chief Justice. And then Justice, who was at Sanford, passed away quickly, unexpectedly, and then Hoover put on Owen Roberts to fill a seat. So those 2 justices shift the court from the conservative wing a little bit to the left, a liberal wing. And then throughout the 1930s, the court decided a couple cases which upheld various progressive legislation and rejected Lochner-style due process clause challenges. I didn't ask you to read them, but I'll summarize them briefly. One case was called O'Gorman and Young versus Hartford Fire Insurance Company. And this was a case of, can a state limit commissions paid on an insurance contract? Right? Can the state set by law what a commission has to be, if it's reasonable? The court actually deadlocked on this case, and then after Hoover and Roberts was appointed, he cast a deciding vote, and he held that the commission law was valid. And the second case was called Nebbia versus New York, 1934. And this case involved whether the state could limit the price of milk, right? And they say we need to limit the price of milk to help dairy farmers. Okay. Allowing grocery stores to charge more money, that money does not get back to the dairy farmers. This is mostly meant to help milk distributors, not actually the dairy farmers, but it doesn't matter, right? The court said we will not second guess the state and their need to use the police power to protect farmers. Again, 5-4 vote. Hoover and Roberts was in the majority, right? He actually wrote the majority opinion in Nebbia. And that brings us then to 36 and 37. We already discussed in Muller versus Oregon, right, that the court held that the state can take into account the difference between men and women, right, and that upheld the maximum hour law. Then in 1923 we had Atkins, and Justice Sutherland said that the difference between men and women have diminished to the vanishing point. As a result, the court said that the federal government cannot have a minimum wage for women. Now you think after Atkins, states would say, okay, we can't enact any more minimum wage laws for women. Not so. Washington enacted a minimum wage law for women. They basically thumbed their nose at the Supreme Court. And then Elsie Parrish, who was a chambermaid at the West Coast Hotel in Wenatchee, Washington, brought a challenge saying, hey, my boss didn't give me the wage, I want back wage or back pay. She basically said, I want to overrule Atkins. And this is an important point. She expressly asked the court to overrule Atkins, and the court did what she asked for. Right? In prior cases, the court wasn't asked to overrule Atkins, but here they were. And now there are 5 votes to overrule Atkins. Okay? Let's start. Lindsay, you want to walk me through, please, the majority opinion West Coast Hotel?
Okay, so in West Coast, Hughes wrote the majority. They overruled Atkins and Hughes stated, if the protection of women is a legitimate end of the exercise of state power, how can it be said that the requirement of the payment of a minimum wage fairly fixed in order to meet the very necessities of existence is not an admissible means? So he was saying that the means and the ends fit one another, and it was appropriate, so it did not violate the 14th Amendment.
Okay, very good. Basically saying that Atkins was wrong, right? I mean, that's more or less what he's saying here. Atkins was wrong. The state has a legitimate interest to protect women, and the decision to fix the wage is a reasonable way of protecting women. And he gives deference to the state. And he actually cites the recent depression, the Great Depression that had ravaged the country. Question whether the meaning of the Constitution changes based on the economic conditions of the day. Would this mean that after the Depression's over, could they eliminate the wage? Think back to the legal tender cases where they said, well, we need paper money because of the Civil War. And then some years later, when the war was over, said, well, even the war's over, we still need paper money. So these sorts of, we need it now because of the exigency, the emergency seldom actually means anything. The court will just continue it later. All right. The opinion of the majority was pretty damn short. There wasn't much there. Basically saying, we agree with Muller, right? The state can take into consideration women's needs, and it's unconstitutional. This was not a minimum wage law for men as well. It was just for women. So, who's being more progressive here? Sutherland, who wants to champion women's rights, or the majority saying women need this extra benefit, right? It's sort of, people always have a little difficulty with this.
Is there a difference between whenever something gets brought up under state law due process and then the federal?
Very good question. Right, Atkins was a Fifth Amendment case, right? The Fifth Amendment due process clause. West Coast Hotel is a 14th Amendment due process clause. The court treats them identically.
Okay.
They shouldn't. They're different provisions of the Constitution, but they treat them in the exact same fashion, right? They should treat them differently. They don't. So they're more or less the same test. Make sure you cite the right one on your exam, but they're treated in the exact same fashion.
But the Atkins, for even though it was state, it's still overruled for the 14th.
Exactly. Okay.
Like,
Very good. Thank you. The majority opinion applied what is often called the presumption of constitutionality. And we've discussed this concept before. In other words, we presume, or courts presume, that the law is valid unless the plaintiff can come forward with some evidence to show that the law is invalid. Right? And here he said the law was valid, right? That in West Coast Hotel, you have this presumption of constitutionality, and that the West Coast Hotel was unable to provide enough evidence to rebut this presumption of constitutionality. In other words, it was possible, if the evidence came forward, that this was an unreasonable law, that the hotel could win. But at this stage during the New Deal, you could still rebut it, and here the West Coast Hotel failed. This, by the way, is the graph that's in your video. It's just a little easier for me to show this than the video. So during the first phase, we call it the rebuttal presumption of liberty. That is, the burden is on the government to justify their law. We saw this in Lochner, and Muller, and Buchanan, and Atkins. In Lochner, Buchanan, and Atkins, the laws were unconstitutional. Why? Because the state could not put forward enough evidence to defend their policies. However, in Muller, because of the Brandeis brief, there was adequate evidence. Blood, water, whatever, right? That was enough, which is why the Muller law was constitutional. This is what we call the first phase. In the second phase, we have this sort of rebuttable presumption of constitutionality, which is the notion that the burden is on the individual, right? If he can show that the law is unreasonable, then the court will say it's unconstitutional. But in the three cases we have here, West Coast, Nebbia, and O'Gorman, the court upheld the state law because they found it was reasonable. The next case we'll get to in a minute is Carolyn Products and then Lee Optical. But in these cases, the court refined and then changed this presumption of constitutionality. Okay, so questions on the majority opinion by Justice Hughes in West Coast Hotel. The dissenters were known, I love this nickname, one of my favorite nicknames is the Four Horsemen, which is a play on the book of Revelation, the Four Horsemen of the Apocalypse, you know, in the end of days where the Four Horsemen come, right? There were four conservatives. There was Justice Sutherland, Justice Butler, Justice McReynolds, and Van Devanter. These were all conservative appointees. McReynolds was the anti-Semite I mentioned. He was actually appointed by President Wilson. It's bizarre, right? Woodrow Wilson appointed Louis Brandeis and James McReynolds. I'm still figuring that one out. Yeah, it never quite made sense to me. I think I'm right about that one, but that one never quite added up. But these conservatives voted as a block in all these cases. And sometimes during this period, Justice Owen Roberts would join the conservatives, go 5-4 one way, and then sometimes Justice Roberts would vote the liberals and go 5-4 the other way. Much like today, it's, you know, the history has a sense of repeating itself. No more Justice Robertses. I think we should just, like, 20th Amendment, no more a justice named Roberts. I think that's a good amendment. It's a cursed name. I'm joking. Owen Josephus Roberts was his name. Good name, Josephus. But at least in this case, Roberts went with the progressive wing of the court. And Justice Sutherland, for him, this was personal because he wrote Atkins, and they just overruled his opinion. So you can imagine he was a little bit bitter, right? And he attacks the presumption of constitutionality. And he effectively says that a judge has an independent duty to make up his own mind and decide if a law is constitutional, right? In other words, the court should not be deferring to the state's defense, right? The burden should always be on the state to defend their laws. They should not get the benefit of the doubt. He also reiterated his position from Atkins that women and men have a legal and political equality, right? You cannot treat women differently based on biological differences, right? Think of the Brandeis brief with the blood in the water, right? Sutherland says you can't put women at this disadvantage. Now, what if there was a minimum wage for men and women alike? I think that'd be a harder call for him. I don't know how it would come out on that one. This is only a minimum wage for women. And that's West Coast Hotel, right? It was a very significant decision at the time because it was viewed as the Supreme Court's retreat. We know that's not what actually happened, but that's how Roosevelt perceived it. And after 1937, the Supreme Court no longer intervened, right? They upheld almost all the federal legislation for the New Deal. They would uphold the various state progressive laws. And at that point, the only limit was the democratic process, whatever laws Congress could enact, right? This was a vindication of, I think, Justice Harlan in Lochner, right? West Coast Hotel is in many regards Lochner's dissent for Harlan, that the court should defer to the state unless the challenger could give reasons why the law is unreasonable, right? Maybe a maximum hour loss for bakers is unnecessary because bakers are healthy, right? But you can at least provide evidence. The West Coast Hotel decision was not an adoption of Holmes's dissent in Lochner. We wouldn't get the Holmes dissent in Lochner until Lee Optical. That would happen, the 1950s, 20-odd years later. But at least for the period of the Progressive era and the New Deal era, Harlan prevailed, which is why I like Harlan. He basically predicted how the court would come down, at least for a good 20, 30-year period. It was his dissent that really won the day. Eventually, Holmes would win, but Harlan had the first victory. All right, any questions on West Coast?
Yes.
Please. What?
So it seems a little contradictory, and maybe I'm not understanding the terminology or the intent. In one sentence, Justice Sutherland says, no, judges should be independent. We don't need to rely on the text necessarily, or the previous opinions. But also, when it comes to extrinsic factors, circumstance, we should pay them no regard. Is that not contradictory to one another? Either we're independent and we're looking at things as we are and as we see them, or we're not. We're looking at them as they were created.
What do you think Sutherland's getting at, right? What do you think he's alluding to there? That we shouldn't be considering these other factors. What do you think he's talking about? What factors are they?
Specifically, changes in economic conditions.
Sure. But what else was going on in Washington at this time?
Just mean the post-New Deal progression?
At that point, Roberts had already cast his vote, but the court packing scheme had become known. I think at some level, Sutherland was actually responding to Roosevelt, saying we should not be in any way making our decisions based on political threats. Moreover, I think he's saying the fact that there's an economic depression, right, should not impact how we make constitutional decisions.
Do you agree with that?
Oh yeah. Yeah, I mean, as a general matter, whenever a court says, "Oh, we're only making this ruling based on the economic conditions of the day," you can take it to the bank that when that condition ends, they won't bring it back. right? This has happened with the legal tender cases. The court said, we're allowing paper money because of the exigencies of the Civil War. Civil War ended. And the court said, well, we still need paper money. So it's basically a cop-out. So whenever a court says, we need this right now, we need to print these papers today, Census, right? I don't ever believe, most deadlines aren't real, right? Right? Parties ask for extensions all the time. They should get them. Things are never as urgent as they can be. A student comes running saying, I need this answer right now. And no, you don't. You can come back later. Reporters call all the time, I need an answer right now. Okay, well, fine. But things are never that urgent. And I think what Sutherland's getting at is we should not be affording this sort of deference based solely on the fact that a law passed the democratic process. It's not enough to give it legitimacy. But it's a very anti-democratic principle, right? You could say, if something passes through both houses of Congress and the president signs it, doesn't that entitle to a measure of defense or deference? Sutherland would say absolutely not. That this is legislation designed for other motives to help certain classes, and we should not give it any deference.
Why did her husband join? Why was he also a party?
I'm sorry, who?
Parrish's husband, why was he also a party?
That's a good question. I don't know.
Because
I don't know if a married woman was allowed to sue in her own name.
Oh, okay.
That's my guess.
What am I getting ready to say? Because he just said equal in legal and political standing.
But coverture. But is that the case? I don't know.
I think so. That's what I learned in undergrad, but I'll make sure.
I want to say it was like 1882 that women got the right to hold property
Married,
in their own name.
but the question is married women.
I think it was married women who hold property in their own name independent of their spouse, but don't quote me, I think it was 1882, but I don't know that was really enforced.
Well, whether you can hold property, can you sue in your own name?
I don't know, I'm just saying that's like the one here.
The entire notion of having a wage only for women is based on the notion that the women can't manage their own affairs. So maybe that's why the husband, actually, I've never asked that question before. I don't know the answer. I'll look into it later.
All right, and last thing for me on this one.
Please.
Is we've talked around it a lot. We've used contract for the last several lectures, and they talk about freedom of contract, etc. What exactly is it federal? The Article 1 reference to contract, what exactly is that?
Okay.
It's not this. What are they referring to?
All right. So there is a prohibition in the Constitution that the government cannot make or impair obligations of contracts. There was a decision decided during the New Deal called Home Buildings and Loan Association versus Blasdell, Blaisdell, Blasdell. And what the court involved was a bar on foreclosure, where basically the state said, remembering correctly, that you can't foreclose mortgages right now. And this was during the Great Depression. So you had all these banks who had all these foreclosed mortgages, they couldn't foreclose on them. And the court basically said, we're in an emergency, right? That the meaning of the Constitution is not fixed, and during an emergency, the states must have enough discretion to violate contracts if it's needed, right? To violate a mortgage, which was a contract.
They did what Sutherland.
And if I remember checking on this, I think Sutherland dissented in Blasdell. I'm pretty sure Sutherland dissented in Blasdell and said, no. The meaning of the Constitution's fixed. Home Building Loan Association v. Blasdell. Am I right? But I think it was Sutherland. I've read that case in years. Yep, dissent by Sutherland, 1934. And Sutherland dissented with Van Deventer, McReynolds, and Butler as the horsemen. And they said that you can't relax the provisions of contracts during times of emergency. After Blasdell, the entire notion of a liberty of contract, or the states, after Blasdell, the Contracts Clause became a dead letter. It just had no teeth anymore. But even before Blasdell, the liberty of contract was different, right? Liberty of contract is the right to negotiate wages on your own terms, right? The right to negotiate working conditions on your own terms. That's different from having a fixed contract, which a state comes in and it says, no, that contract's no longer effective, right? You have a mortgage contract, we're no longer going to enforce that contract. Those are different concepts.
Got it. Okay.
Yeah, but Blasdell's a good case. Maybe I should teach, I don't know, but it's an important New Deal case from 1934, which had before 36, right, before 37, before the switch, where you had the court. Who was in the majority there? I'm guessing it was the same 5-4. Who wrote that one? Hughes? Yeah, it was Hughes. Hughes wrote the majority, that's right. But yeah, it was a pre-36 case where the court ruled based on the economic conditions of the day.
When did, so wait, I'm sorry, when did the new court, or New Deal court, when did they end?
When did it begin? When did it end?
It began in
Oh God,
1983.
Randy and I had a long discussion about this last week. We eventually decided not to give a date. There's no good starting and stopping date for the New Deal, right? Because Roosevelt had like two of them. There was the first New Deal and the second New Deal. And the first New Deal I think was in 33, and the second New Deal I think was in 36 or 37. But the actual change in the court, the big ones were in 30 and 31 when you had Roberts and Hughes replaced Sanford and Taft. That was the big change. But yeah, Randy has discussion. When did the New Deal begin and end? And there's no good year, so we just didn't give one. That was quite deliberate. We never actually defined when the New Deal was because it's too hard. Because it went beyond 37 in many regards. Lindsay, I think your hand was up a minute ago.
So I have a question about
Please.
Sutherland.
Yeah.
So
Justice Sutherland.
in Atkins, he held that it wasn't proper.
Is that the
And-
minimum wage, right?
Yes, and then in this case, he dissents, and to me, it sounds like Sutherland thinks that everyone's being reactionary by changing the law. Was he very, like, I guess,
He was conservative.
against
Yeah.
changing the law from what it was, and
Yeah.
that's why he talks about, like, the ebb and flow of
Yeah.
economic events
Yeah.
and things like that.
Yeah, he thinks the Constitution's fixed. It's a very originalist dissent
Okay.
he wrote. And of course, the other dilemma, of course, that Sutherland dissented in Pierce of Society of Sisters.
That's-
Oh, no, I'm sorry, in Meyer v. Nebraska. He dissented with Holmes and Meyer in the German language case. He also joined the majority in Buck v. Bell. All right, so Justice Butler was the only horseman who didn't join the majority in Buck v. Bell. Yeah, I'm racking my brain here. My brain's scrambled with the Roberts stuff, but the current Roberts stuff. But I think I'm right what I'm saying here. Oh boy. Okay. All right. So, any other questions on the Sutherland dissent or the majority opinion by Chief Justice Hughes in West Coast Hotel? Yeah, very important case. Very important case, West Coast Hotel. Even if it didn't actually have a switch in time that saved 9, it marked an inflection point where the court changed the way they approached due process cases for many years to come. And it was also an important point because shortly after West Coast Hotel, the composition of the court changed radically. The four horsemen, they disbanded. They rode off into the sunset. Sutherland stepped down, Butler stepped down, McReynolds left, Butler also left in that period. And by the time FDR was done, he had made 9 appointments to the Supreme Court, where it's a stunning amount. I mean, other than George Washington, I think he had the most Supreme Court nominees of any president ever. He had 4 terms as well, but it was a significant change. But the point that Randy wants to make sure you understand is that the change didn't happen suddenly in 36. It began in the 30s as this presumption of constitutionality was established. Yeah, Randy's very big on that point, so we make sure to make it very carefully. Did I show you the cover of the book? Did I show you? I'm going to show you. I forgot to. I'm sorry. I should have showed it to you before. Here's the cover of the book. If you don't like it, too bad because it's fixed. Did I?
Oh, I made
I think so, unless you changed it.
No, the 100.
Yeah, you showed it to us.
Did I show you this one?
Mm-hmm.
Okay, cool. All right. Okay, and I'll show you this one also. We have the headshot for me and Randy. Let's see, where is it?
How old were you?
No, we did it a few months ago. The headshot for me and Randy for this will be in the book jacket. Yeah. Not old enough yet. Not old enough yet. And these I like. I got a cartoon, a caricature of me and Randy. This is the Randy one. And this is the Josh one. Hold on. Yeah. Not sure we're going to use them for, but we got these designed. Okay. Yeah.
Who did that?
I hired a cartoonist. Yeah.
So, fun fact, the original lawsuit was filed under her husband's name. It was Ernest Parrish for
Really?
West Coast Hotel.
Was that in the district court?
Yes.
Does it say why the husband was involved?
It just begins to talk, and the opinion starts from August 1933 to May 1935 when plaintiff was in the employ, but the plaintiff is listed as her husband.
I don't know. If I had to guess, it was probably some sort of coverture issue. I think Washington was a community property state. It is still to this day that a woman can bring the suit in her own name. I don't know. I've never seen asked that question before. I'll check into it. All right. All right. We did West Coast Hotel. Let's move on next to Carolyn Products, which was one of my favorite cases. Oh, I forgot. I have a bunch of Milnut cans in my office. I forgot to bring them. And I have all these Milnut recipe books, which you can see in the video, but I actually have them in my office. I got Randy one of them a couple years ago. All right. Have I only called on one person today? Chelsea, even like,
I think Chelsea.
are you next?
I haven't gone yet.
Oh.
Okay. Yeah, you've been dangling for the last hour. Okay. All right, Chelsea, do you want to give me, please, the facts in U.S. v. Carolyn Products?
So Congress passed the Phil Milk Act, which prohibits the shipment and commerce of skim milk compounded with any fat or oil other than milk fat.
Okay, so why, just to understand, why does filled milk remove the dairy fat? What's the purpose of removing the dairy from the milk?
Because it makes it where it can be stored without.
Yes, without refrigeration, right? Today we take it for granted, but at the time this was an innovative product, right? You could actually have dairy, right, in a can that didn't require expensive refrigeration. You could transport it across states. You could keep it, in your cupboard. We have filled milk today. You go to the store, buy was it Carnation or these different brands. Did anyone ever have Milnut? It's very popular in the South. I'd never tried it before, but apparently, actually not apparently. The librarian, do you know Colleen in the library? She's the director of the library, Manning. She actually made a Milnut pie, and she brought me a slice. Oh my God, it was so sweet I couldn't eat it. It was so rich. Like, I think she's from Oklahoma. It was like the richest thing ever. I took one bite. I was like, I'm sorry. It was too much, but she was very sweet of her. But it's very sweet. You make like a pie out of like the filling and stuff. Anyway, so the producers, like Carolyn Products, made this product called Milnut, and it basically replaced all the dairy fat with vegetable oil, coconut oil, or some other vegetable product. And that allowed it to sit on the shelves for weeks on end, months on end, years on end. Now, who was unhappy with this? The dairy farmers, right? The dairy farmers don't like competition. And at the time, the dairy farmers were very influential. In fact, they had two or several major enemies, right? One enemy was condensed milk. The other enemy was margarine, right? Margarine is a chemical-based butter substitute which does not require refrigeration. States actually passed laws banning margarine. Other states passed laws, I'm not kidding you, that require dyeing margarine pink to avoid confusion with butter. You want to put some pink margarine on your bread? No, you don't. Oh, I got to give a correction. Last night I did Buck T. Bell, and I said that Carrie Buck was raped by her stepfather. That's wrong, and I have to fix it in the book. The relation is actually more complicated. Emma Buck gave Carrie to the Dobbses, was a family. And there was a husband and wife, and they were her caregivers, which I thought they were the stepfather, but they were never actually adopted. So these were basically just caregivers for her. They turned into a Cinderella. She was a slave, right? She would cook and clean. It wasn't like a daughter. It was basically a Cinderella thing, right? At one point, a nephew of Mr. Dobbs came over and he's the one that raped Carrie. So it wasn't the caregiver, but it was a nephew of the caregiver. And that's why they tried to keep it under wraps by putting her in the colony, because they didn't want to get their nephew in trouble. So I got to make that correction. I sent a note to the publisher last night. The second I got home, I was mad at myself. I said the wrong thing, and I fixed it. No, it matters. I like getting stuff wrong. And a fact like that, it's not, I don't like screwing that fact up. That's an important fact. All right. Back to Carolyn. Right, so the milk producers hated filled milk. They hated margarine. So they got a lot of states to enact bans on filled milk. And then they got Congress to enact a ban on filled milk. And the government concluded that this is an unsafe product and it's harmful to public health. Now, the irony, of course, is it's perfectly healthy. And in fact, it's healthier than real milk because it doesn't have the cholesterol, right? It's actually, in many regards, healthier to eat the condensed filled milk with vegetable oil than it is to actually eat the dairy fat, right? But, you know, Congress made a finding, hashtag science, right? That was the science of the day. And who's the court to second guess it? Now you have Charles Hauser, who was a fascinating guy. I wrote about this case years ago, and I got an email out of the blue from a woman named Donna Statley, and she's his either his granddaughter or his grandniece. I can't remember which one it was, but she was a close relation to Hauser. And she said, you know, he's my uncle. I'm like, wow, that's so cool. Or my grandfather. It's like, oh, that's so cool. And then she tells me this story, and she goes, do you know how the court many years after Carolyn Products held that Milnet was constitutional, or held that the Filled Milk Act was unconstitutional? What are you talking about? That didn't happen. She's like, yes, it did. And then the reason why you have the district court opinion in your book is because, like her, no one even knew this existed. Randy didn't know. And he actually, funny, he copied my stuff in the second edition of the book without me, but then I got onto it eventually. But she told me this story of how after her grandfather died, the court actually ruled that the Filled Milk Act was unconstitutional, which is a stunning story. But let me give this other bit. She also told me this great story, which I'm certain is not true, that after the Supreme Court ruled in Carolyn Products, her grandfather was intent on challenging the law again, and he personally drove a milk truck over the border from West Virginia. Now, I can find no evidence this is true, but she tells us a family story that she drove over the border with this milk truck to break the Filled Milk Act to challenge the law. And apparently, Hauser's lawyer told him, no, they want to arrest you. Of course, they arrested him, and they threw him in jail. And the jailer didn't want to keep him there, so he brought him to his house for the evening. Because he was a businessman, wasn't going to run away. Anyway, so long story short, Hauser lost Carolyn Products 1, he lost Carolyn Products 2, and he was actually sentenced to jail time. Several of his associates actually went to federal prison. They willingly broke the law. And at the last minute, FDR gave him a pardon, which is in your book, which is a stunning story. No one knew this till Statley told me this stuff. He gave a pardon to Hauser. And Roosevelt died about a month or two later. So this is one of the last pardons Roosevelt issued. Fascinating story. She told me all these anecdotes, like, you know, Hauser, whenever he went to the airport, would never get on the plane right away. He wanted them to call his name. You know, Charles Hauser, please go to the plane. Why? It's free advertising. And so he was like this sort of, this business maven, right, who always had these ideas. And his greatest accomplishment was building this factory that straddled the state line. And the idea was, because the filled milk would never cross state lines, he wasn't violating the federal law. He would have cargo doors on both sides of the building. So once you had the filled milk, one would go to one state and the other state. Now, sadly, that factory closed down this year, just this year. I never got a chance to visit. I was invited to go, and I could never make it work, so I'm sad about that. I wish I had, but couldn't make it work. But it was in Oklahoma, but the factory was shut down. But it was this amazing thing. I talked to the plant manager who worked there for like 40 years, and he was like in his 90s, and he said they actually had a brass rail down the middle, and they knew once you had filled milk, you could not make milk cross that brass rail, so they would keep everything separate. Fascinating story, right? The footnote to footnote 4 is much more interesting than the actual case. The actual case is pretty boring, right? The actual case is straightforward. You had literally the interstate shipment of filled milk, and under the presidents like Darby and Jones and Laughlin Steele, this is easy, right? Congress could regulate the shipment of filled milk. It was interstate commerce. It had a substantial effect on interstate commerce. Piece of cake, right? Easy. But the reason why we study Carolyn Products is not because of Charles Hauser's case. It's because of a footnote. The fourth footnote. The most famous footnote probably in Supreme Court history. And the reason why we say this footnote is because it articulated an entire theory of constitutional law that proved to be very influential. Specifically, it qualified the presumption of constitutionality. Generally, after the New Deal, the courts would review all laws with a presumption of constitutionality, except where footnote 4 applied. Where footnote 4 applied, the court could apply a more rigorous standard of review. And the court might actually scrutinize things. We might say strictly in modern language. Right? They would strictly scrutinize laws. If one of the paragraphs of footnote 4 was triggered. So the challenge became this, right? How can the court simply turn a blind eye to injustice, right, with this rational basis review? Aha. If it meets the criteria of footnote 4, the courts can still go Lochner on them, right? They can go Atkins on them. But usually they can't. And that's why you have these 3 important paragraphs in footnote 4. If I can give you any writing advice for your briefs, don't put important stuff in a footnote, right? If it's important, just put it in the damn body of the text. But alas, here the justices slammed this footnote in, and here we're stuck with it 90 years later. One other note before I get started to footnote 4, the case only had 4 justices join it, right? There were recusals and otherwise people not involved, dissents. So this wasn't even a majority opinion. Justice Scalia, one of my favorite lines, he called those who favor footnote 4 dictamizers, right? This was the dictum, right? He called them footnote 4 dictamizers. I miss him. But it was just a wonderful line. The court never said, this is unconstitutional because it violates footnote 4. That's not a holding, but proved to be very influential. Okay. So let's walk through it one step at a time. So the first paragraph, let me read it for you. It says, there may be I can't say this word, a more narrow scope. Try that, narrower. I'm unable to say that word. There may be a more narrow scope for operation of the presumption of constitutionality. What does that mean? This presumption of constitutionality from Westcott Hotel may not apply when legislation appears on its face to be within a specific prohibition of the Constitution, such as the first 10 amendments. In other words, if you have a law that violates the freedom of speech, it does not get the presumption of constitutionality. That the state still has the burden to show why its restriction on the speech or on the press are justified. This is what's known as strict scrutiny, right? When you have an enumerated right, enumerated in the Constitution, written down, it gets heightened scrutiny, right? When a law violates an enumerated right, you do not give it the rational basis test, you give it heightened scrutiny. Now, there's an important implication here. Is the liberty of contract enumerated? No. It's based on the word liberty. It's based on what we now call substantive due process. What the first paragraph of footnote 4 effectively did was it said, bye-bye substantive due process, no mas, right? If you have an unenumerated right, you get rational basis review, and the burden is on the plaintiff, not the state. No more Lochner, no more Atkins, right? It's saying for economic rights, you're stuck with West Coast Hotel and a rational basis review. And again, what about Meyer? What about Pierce? Right? These were cases based on the word liberty, and they were not enumerated. Were then Meyer and Pierce wrong? This created a little bit of uncertainty, which is why later the court would say these were actually First Amendment cases, to bring them within the structure of footnote 4. Right? The reason why Meyer and Pierce were recast as First Amendment cases was to jam them into the first paragraph to justify the heightened scrutiny that they receive. Okay, everyone with me? Okay, that's the first paragraph, footnote 4. Any questions? Okay. Okay, let's do the second paragraph. Oh, by the way, Randy will be mad if I don't mention this. The Ninth Amendment, which is his baby, says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Exactly what this means is subject to debate, but at a minimum it means that rights that are unenumerated should not be treated worse than rights that are enumerated. Footnote 4, in many respects, directly conflicts with that, because it says rights that are not written down should be treated as second-class rights. So I did my duty. You're welcome. He doesn't actually review my classes, but we talk about these things. Okay. Let's do the second paragraph. So second paragraph says, it is unnecessary to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny. Okay? What does that mean? If there's some sort of legislation that restricts the right to vote, restrains a political organization, that might get more exacting judicial scrutiny, which means strict scrutiny. In other words, there's no presumption of constitutionality for laws affecting the right to vote and laws affecting representation. And this is known as representation reinforcement. The idea is this. Generally, if there's something bad going on, the people can change it through the electoral process. But if people can't vote, they can't change it. Right? You can't change a law if you can't vote, or if your vote's diluted, perhaps. As a result, the court will step in to reinforce these political rights to ensure that the electoral process can then remedy other problems. Right? That if there's some really bad law, make sure people can vote, then they can get rid of it. If they can't vote, what are you going to do? Court steps in. Okay. So questions on the second paragraph of footnote 4? No? All right, let's scroll down. The third paragraph says, nor need we inquire, and let's try to put this in the screen all at once. There we go. Nor need we inquire whether similar considerations, that is, do we apply heightened scrutiny, for the review of statutes directed at religious or national racial minorities. And look what they do here. They say that Pierce was involving a religious minority. It's not accurate. The case had nothing to do with being a religious school at all. In fact, the Hill Military Academy wasn't religious at all. Or national minorities, that is, based on German. Well, no, again, it didn't involve people being German, it involved teaching German. These were not laws targeted at these national minorities. Whether prejudice against discrete and insular minorities. Okay, what does that mean? Insular, think of like insulation in your house, right? It means like closed off, and they can't access the sort of political channels they need to make change, that they're like secluded, right? Whether prejudice against discrete and insular minorities curtails a political process to protect minorities. In all these cases, you may need a more searching judicial inquiry. Now, usually someone asks, Josh, what's the difference between paragraph 2 and 3? Not very much. There's a lot of overlap. This is not a particularly well thought out breakdown. But generally, the second paragraph concerns political process, and the third paragraph is specifically certain types of racial and discrete minorities and the political process. And all these cases, you get heightened scrutiny, right? Not all legislation is reviewed with deference. If a law violates the Bill of Rights, for example, you get strict scrutiny. If you have a law that violates the political process somehow, you give it heightened scrutiny. If you have a law that curtails the rights of minorities, heightened scrutiny. Now, if only were that simple. This is merely sketching out what could be. No court actually held that this is law. It's cited every now and then, but it's not actually law. It describes merely a theory of constitutional law that the court sometimes discusses. Okay? So as a general matter, you apply the Harlan standard from Lochner, right? You apply the presumption of constitutionality. That can be rebutted. But if you fit within the 3 paragraphs of footnote 4, you apply a heightened scrutiny. Really what the Lochner majority applied, right? The sort of heightened means end scrutiny.
You said on our finals that you can't just like cite footnote 4 and say like.
Again, you can discuss it, but it's not like a binding precedent, right? That's not like a case that it doesn't resolve any cases. It might inform a case, but it doesn't resolve it.
But it's like if you put us in some sort of time period where this would be applicable, we can say the court could discuss.
Yeah, if Carolyn Products was decided, I think it's a relevant discussion, but it's not like you know. For example, like Wickard gave us the aggregation principle, right? This is not like a principle that you can apply to resolve a concrete dispute. But the important point is that footnote 4 qualified and modified the presumption of constitutionality. Most laws are given the Harlan approach, but if you fit within the footnote 4 exceptions, you get strict scrutiny.
Is the rational basis?
It's Harlan.
That's the presumption of constitutionality.
Exactly. Right. In other words, the court presumes the law is valid unless the plaintiff can come forward with evidence to suggest otherwise. Right? Think of Carolyn Products. Maybe Charles Hauser could have put forward some evidence showing that filled milk was healthy. The problem is you have Congress making a finding to the contrary. Right? Congress actually did its job, and the courts are not going to second guess that in a rational basis review standard. Science.
Yeah, that's what I was thinking of. What evidence?
Well, the optical is a good example. The next case, right, in the district court, which is why it's there. Randy loves that district court opinion. It's the only book in the country, I think, with that example in it. All right. Any questions on Carolyn Products footnote 4 or the body of the opinion? Yeah, poor Charles Hauser. He got his pardon, but he never lived to see his milk be legal to ship in interstate commerce. I bought an entire case of it some years ago. I've never actually tried it. I have an entire case of it. I tried the cake, but I've never tried the actual milk. I also have a case of Ollie's barbecue sauce. I have a lot of stuff. Okay. Any other questions on Carolyn Products? All right, let's do the last case, which is the optical, which is again is an important case. Or do you want to start me off with just the facts, and we'll do the district court opinion first?
Yeah.
Thank you.
So for the optical, do you want me to go into the definitions first?
Sure. Just give me the facts. What was the law that Oklahoma adopted?
It was the Oklahoma law that made it a violation for people that manufactured glasses, that they had to get the doctors had to get a prescription before they could actually.
Very good. Right. So I see that almost all of you are wearing glasses. You have glasses?
No, I'm actually 20/20. Near and far.
Yeah, I didn't have glasses until I was like 32 or 33. It'll hit you. Right. Eventually, everyone needs glasses. Tyler, you have glasses?
No, sir.
Yeah, I'll hit you eventually. Everyone does. I didn't get into a couple of years. If you watch my older videos, I didn't have any. I'm stuck with them. If I take these, you're really blurry. We have today places like lens crafters, right? Where you can walk into the mall, you hand them your lenses, they can manufacture a copy of it in a fairly short period of time, right? And they use this device called a lensometer, which means you basically put the glasses in and you sort of spin some dials and you can see what your prescription is. Oklahoma passed a law saying that to make a pair of glasses, you need a prescription. Now, maybe your prescription changed, so you need a new one, but if your prescription is the same, why should you get a new doctor visit? The Optical challenged the constitutionality of this law. They did not employ ophthalmologists, which are the doctors, or optometrists. They only employed opticians, which are basically lab techs. And they argued that this was a violation of the Equal Protection Clause. It was unconstitutional, that the state drew an arbitrary distinction between eye doctors and opticians. The opticians were just as qualified to make the lenses, and they didn't need a new prescription. Okay. All right. So now, Tyler, walk me through, please, the district court's opinions. It was a 3-judge panel. Back in the day, when you challenge a state or federal law and you challenge a constitutionality, it wouldn't go to a 1-judge district court. It would go to a 3-judge panel with a mandatory appeal to the U.S. Supreme Court. I often favor that approach. It's much better than the nationwide injunctions racket we have now, but that was how it worked back then. So, Tyler, walk me through the district court's opinion, please.
Yeah, so they thought that it was an arbitrary and oppressive means by the state, that it was an unconstitutional deprivation of the merchant's ability to conduct business. So their next level appeal from that 3-judge panel was based on that.
Why? I'm sorry to interrupt. But why was it arbitrary? Right? Why was it so oppressive? What about the law was unreasonable?
That even, because I mean, it was even ophthalmologists would say that the opticians could perhaps perform the task with a higher degree of proficiency than they could. Therefore, what was the benefit?
So the question here is this law justified? Right? Think of Lochner for a minute, right? Does the state actually have an adequate justification to limit bakers to 8 to 60 hours a week, right? Here, does the state have an adequate justification to limit the manufacture of lenses to eye doctors? And actually,
they did. Yeah, I mean, they think so.
And Lee Optical puts forward evidence saying that, look, we can do the job just as well, and there's no real health concerns here. So you know my question's me, says who, right? Is this evidence that's incontrovertible, right? Maybe the state could decide we want people to get eye inspections at irregular intervals to prevent health issues, latent health issues. And one way to encourage to have more eye doctor appointments is to prohibit getting your lenses duplicated, right? Tyler, why is that not a valid defense of the law?
It seemed like, I mean, I didn't know, the 3-judge panel seemed like it was butchers, you know, and then bakers, and now it's lens crafters.
Eyeglasses makers.
Right?
There you go.
I mean,
You're welcome.
And then it's looking at a specific class of individuals. Therefore, their precedent was that it was not legitimate.
Yeah, I mean, there's a lot of overlap between this case and the sort of Lochner majority opinion, although not exactly, right? Here, Lee Optical came forward with evidence showing that we can do the job just as well. And the court said, we agree, right? And that this law is imposing a discriminatory classification between eye doctors and opticians.
But with Lochner and even Slaughterhouse, it's the intent, the legislative intent seemed a bit more clear. What was there like?
Okay, I was going to get here in a minute, right? So I'll call on you, Tyler, because you asked the question. What did Justice Peckham think, or why did Justice Peckham think that the New York Bake Shop law was enacted? What?
I think it wasn't it just to improve eyesight?
No, the Bake Shop Act in New York.
Oh, okay.
Why did Peckham think the Bake Shop Act was enacted? He had a very specific phrase here. I remember?
Wasn't it to help the larger?
Other motives. It was to help the unions, help the larger bakers. And here, I think the 3-judge panel suggests that this law was not enacted to promote eye health. It was enacted to help local eye doctors keep their shops open and to punish this out-of-state business. I think that comes through in the district court opinion, right? So there are some overlaps, and the court basically says that the state lacks an adequate justification, right? In other words, we don't know exactly why this bill was enacted, right? We don't have a history record. We don't need that. What we can show is if the state was actually concerned about health, they would be doing something a little bit more stringent, right? But this law has nothing to do with health. It's completely secondary. Right? And they actually suggest that this law was enacted based on a pretext, right? Where they did it for one reason, but it was actually another reason. Yeah, the other motives, right? That the means chosen was arbitrary and oppressive and not adapted to the accomplishment of the end sought. You should not punish these out-of-state businesses. But this was a fairly rigorous review. Now, Randy thinks that the district court decision was consistent with West Coast Hotel. I'm not so convinced. I think it's more Lochnerrian. But the general gist is this applied a meaningful standard of review, right? Was the district court decision consistent with footnote 4? I don't think so, but it's close enough. It's a close enough call, right? For certainly the Supreme Court decision was a different direction altogether. But here, the district court applies fairly rigorous review. Did that answer your question, Tyler Irbett? Okay. All right, so that's the district court opinion. But that's appealed by virtue of the Supreme Court, and we get a very different decision, right? Lindsay, you want to walk me through the SCOTUS decision by Justice William O. Douglas, who was a New Dealer. He, I guess you read his decision in Korematsu and in Endo and in Hirabayashi. I think you read his decisions there. I can't think of any other Douglas decisions you read, so I don't think so. Good.
So they reversed the district court and said that it was not the role of the courts to balance like the pros and cons of the Oklahoma law.
Uh-huh.
And that if there's a rational basis or a conceivable basis for the law, there's no meaningful reason to review the law.
Exactly. Very good. Thank you, Lindsay. The big change between Carolyn Products and Lee Optical concerns the presumption of constitutionality. What Lee Optical does is it basically eliminates the opportunity to present evidence that the law is irrational. How does it do this? The court says we will presume the law is rational, and for evidence we'll consider not only what actually exists, but what could exist, right? Randy uses the phrase conceivable basis review. If the court can conceive of any reason why the law is valid, that's enough, right? Perhaps we could say that the state wants to have people going to the eye doctor more often to encourage eye health. So therefore, every time you get your lenses made, you have to go to an eye doctor. Of course, that's not true because you can get your lenses made without a prescription from an eye doctor. They don't need to actually examine you. So there's not actually a fit between those means and the ends. But they don't require such a fit. Why? Because it's not for the courts to second guess the motivations of the legislatures. So long as there was some rational basis that could have motivated the law, that is enough. Right? So long as the government might have concluded the law is reasonable, that's it. And Douglas gets his test. He says, it is enough that there is an evil at hand for correction, and that it might be thought that there is it might be thought that there is a legislative measure. I'm sorry, I screwed that up totally. Can't read. It is enough that there is an evil at hand for correction, and that it might be thought that the particular legislative measure was a rational way to correct it. And that's the statement of the sort of rational basis test. Once you get to Lee Optical, the court basically said, we're hands off. Unless you can fall within the footnote 4 paragraphs, the law is valid. Right? Unless you can meet one of the 3 paragraphs of footnote 4, don't come to the courts, go to the political processes. We'll keep the political channels clean through footnote 4. We'll keep the Bill of Rights protected, but other than that, you are on your own. We are not going to strike down state laws because they are unwise, improvident, or out of harmony with a particular school of thought. And here he's channeling who? Holmes, right? This is channeling Justice Holmes and Lochner. right? The courts no longer set aside laws that run afoul of certain economic theories. That is Holmes. So Harlan was the West Coast Hotel and Standard. By the time we get to the optical, it's Holmes, and Holmes prevailed the day. From 1955 for about a decade or so. All right, questions on West Coast Hotel? Now, I said it prevailed for about a decade or so because in the 1960s, the court moved away from this presumption of constitutionality. It was only used for a good 15 years or so. Let me walk you through this history of the due process clause. Initially, at least, the court applied what could be called a rebuttal presumption of liberty in Lochner, Muller, Buchanan, Atkins. And in these cases, the burden was on the state. The government had the burden to demonstrate that law was irrational. I'm sorry, that law was rational, that law was reasonable. And generally, if you notice, when you have a burden, you're going to lose. Muller was the only case in which the government prevailed. Why? Brandeis, right? He had evidence showing that the women were inferior and needed this protection. But this only lasted about 20 years or so. We fast forward to the second stage where we have the New Deal cases. And West Coast Hotel and others illustrated that you presume the law is constitutional, and the burden shifts to the plaintiff to show that the law is unreasonable, the law is irrational, that there's not an adequate fit between the means and the ends. Then we fast forward to footnote 4, which modifies the presumption of constitutionality such that certain laws affecting racial minorities and the political process would still be reviewed with heightened scrutiny. And by the time you get to the optical in 55, the court says, unless you go to the footnote 4 criteria, you lose, right? The courts will simply rubber stamp it. And they will not provide any meaningful scrutiny to laws that violate unenumerated rights, such as the right of contract. So the opticians in the optical are out of luck. This is the embodiment of Oliver Wendell Holmes. If my fellow citizens want to go to hell, I will help them get there. He said that. Okay, questions on that timeline?
Caroline falls into New Deal?
This is
Or
why
is it
it's so hard to give a year. That's why we've had this argument. It is basically 1 year after West Coast Hotel, but it's a different era for our purposes.
There's like a gap between like the New Deal court and then the Warren court.
Yeah.
And this what falls in between? Or?
Yeah. On my timeline, I explained that.
Yeah, there's not a good answer.
Okay.
It's not like at the time they said, oh, here's what we're doing, right? This is all hindsight's 2020. So we at least marked the point where things changed. But yeah, the timing is not ideal. So the New Deal basically went into the early 40s, right? But this is why we like these stages better than calling them based on historical periods. Now, the fifth stage you'll see in our readings for not next class, but a few classes later, is that the Warren Court begins to hold that there's certain other unenumerated rights that are important, such as the right of privacy, such as the right of abortion, right? Even those rights are unenumerated, the court would still review restrictions on those rights with heightened scrutiny, and the court basically cracks open the footnote 4, the optical settlement, right? They break it open. So under current law, liberty of contract, for example, is still reviewed as a non-fundamental right with a rational basis standard. However, laws violating other fundamental rights like privacy still get heightened scrutiny. So the dilemma for Justice Douglas is this. He wrote the optical, and then he wrote Griswold v. Connecticut 15 years later, which discusses a right to privacy of married couples. So how does he reconcile the optical with footnote 4? How does he reconcile right of privacy with these decisions? What he effectively says is that the right of privacy is based on the Bill of Rights, that there are penumbras and emanations from the Bill of Rights that justify right of privacy. And because they relate to the Bill of Rights, you get within the first paragraph of footnote 4, and you get heightened scrutiny for laws that violate those. So when you get to Griswold, I think we'll do Griswold. God, this class moves so fast. I never remember where the hell we are. We'll do Griswold next Wednesday, a week from today. When we do Griswold a week from today, you'll see how the court tries to frame the right of privacy as part of the Bill of Rights in order to get within footnote 4. So you're still here in the third stage. But the court would never reverse the fourth one, the obstacle. Questions? Okay. Tomorrow we pivot. We take a different direction for a few classes. We start the Equal Protection Clause, and we do the school desegregation cases. We do Brown v. Board of Education, Bowling v. Sharp, Cooper against Aaron, and Loving versus Virginia, which were important civil rights cases. And then we'll do affirmative action on Monday. On Tuesday, we'll do gender discrimination. And on Wednesday, we come back to substantive due process with the privacy cases. Moving along very quickly. And then we have 4th of July, so we have a day off. You don't have to drive for 5 hours. Good.
Do we do anything with the Fourth Amendment in this class?
Not in this class. If you
Okay.
take criminal procedure, you'll do a lot in the Fourth
Okay.
Amendment. Fourth Amendment, Crim Pro is ConLaw. If you want to do,
I just didn't know if we got it in here or if they did it.
No,
in
I don't have
Crim
time to.
Pro. Cool.
okay, anything else? All right, have a good night, guys. I'll see you on tomorrow night. I'm gonna be very stressed tomorrow. Just warning you, it's gonna be, whatever happens, I'm gonna be annoyed. It always happens last.